Hello, everybody. This is Alden Parker. I'm the regional managing partner for the Sacramento Central Valley office for Fisher Phillips. It's an international labor and employment law firm. I also serve as the co-chair of our hospitality industry group. About 25 years ago, I started representing restaurants, and over my career, I've really grown that focus. Now, I would say the most important thing for someone starting a restaurant would be to vet and understand what payroll system and timekeeping software they're going to use in their restaurant. Having daily attestations built into someone's POS system where people are tracking time, having issues where someone out of state, a payroll provider and a timekeeping software isn't going to round time in California. All of these aspects are fraught with liability for the new restaurateur, and they start creating the liability and replicating it over and over again by the minute, the moment you have opened your doors. That's where I would start first and foremost, is understanding that aspect of what you're going to do in your employment relationship with people. But the restaurant industry in particular is ahead of a lot of other industries in terms of the tech that we can bring to bear to go ahead and control wage and hour issues. Daily attestations and auto pay are really where there's a lot of bread and butter, and it's not sexy work. It's not the creation of this amazing space for people to come and gather. It's not the creation of a fantastic menu, and that's what a lot of restaurateurs want to do. But before they go ahead and do that, they've got to go ahead and lock down their wage and hour compliance, because that is the thing that can undo all of it. Your traditional employment practices liability insurance, EPLI, is going to cover, depending on your deductible, your carrier is going to be covering things like, your FEHA claims, your claims under the California Family Rights Act, a lot of the claims that you might experience, retaliation claims for complaining about wage and hour violations, which are very in vogue. And so good, solid management structures can control those losses. But the dynamic there is it's one person still. And so I, as the litigator, I have one target I get to focus on in the litigation. In a class action or a PAGA case having to do with wage and hour, it's not just one person, but that one person is representing everybody else that is either currently working for you or even those that have left you during the statute of limitations. All of a sudden, you've lost control. You have so many different targets to hit. It's a very, very difficult case to defend against. There are ways to do it, but having a singular focus like those other claims I've mentioned is much more beneficial to the defense. When you're starting a restaurant and you're doing that initial hire, you're over hiring for the positions, which is naturally going to create a situation where you're going to contract your workforce. You're going to be, I wouldn't use the word firing, but you're going to separate some people probably within a few weeks of opening. Once you get your schedules down, you find out what the appropriate level of staffing is. And that contraction, those people have already worked a few hours for you. So again, that sort of, not to gild the lily, but it certainly goes ahead and informs why when you ask what's the most important thing for someone starting a restaurant to focus on, it's the wage and hour side. And that's a immediate risk that you're taking on in a very short amount of time. I like to focus on the things that we can control in hiring. I think making sure that someone can appropriately fill out an application, someone that can be friendly and engage with a manager in dialogue for an interview is important. The best an employee is ever going to be is during that interview. They can't dress appropriately, or they can hardly speak to you appropriately. Those are things that should be disqualifying. And far too often in the rush to hire, our managers are making poor decisions. They're not taking those clues. But the uncomfortable question is always for the manager to answer: how did you hire this person? How did they get past whatever screening you were doing? And typically the response, which is not a good response, is I was in a big rush to hire. I had to fill these positions. And so I just took everybody that was available and I figured I would sort that out later. and we've got to take those clues from the initial impression. The 90-day probationary period is as much of a fantasy under the law as a dragon. So 90 days is a period of time where we're setting expectations, and it can be useful in litigation, but it is not going to remove anything from court. The 90-day probationary period and at-will employment simply means, look, anybody can decide to leave or stay in employment or have someone go from their employment relationship for any reason or no reason at all, so long as it's not an illegal reason. And that's the hook. That last phrase is so important that it is extremely rare we see someone just sue for wrongful termination. So the wrongful termination lawsuit would be the only place it applies. And in the end, it doesn't mean anything. If something illegal happened during those first 30 days, 60 days, 90 days, or even on the first day, you could be liable for it, even with a 90-day probationary period. At the end of the day, if you are entering and becoming a restaurateur in California, you have to know that you are in one of the most litigious environments and hostile environments to employers that you can face. And the ease in which an employee can now, or a former employee can now get in touch with an attorney, it no longer is late night ads or billboards that they have to stumble upon to find an attorney. They pick up their phone and they go ahead and immediately can put in a couple keywords, and the advertisements start to blitz their feeds. I think that having a couple resources available is really important to a restaurant. I think one resource is you want an employee handbook. It sets the baseline or the foundation for your relationship with the employee, and it's something that managers can use in their daily interactions to point to with employees about what the company's policies or procedures are going to be. And the absence of one will lose you an employment lawsuit. And so it's a one-way door. It's not going to win you, but it will lose you an employment lawsuit if you don't have one. So that foundational document should absolutely be there. Restaurant owners are so good at creating the experience and doing amazing things with environments and with menus and with their customers. I think they need a resource on when issues inevitably come up with employees. Who can they call and ask questions about that do tend to be more legal, and you can gain from that experience. That experience is going to arm them with, I think, the perspective on the questions that are going to come up with their employment relationship. I would get those two resources in line. And every year, that building over my shoulder, they don't decide, hey, we don't need that law anymore or that rule anymore. They just add more. And so every year, those handbooks tend to go ahead and need to be updated. Despite what words are in the handbook, the practices of the company may have been different, or they may validate what that policy says, but they ignore that. They look for the got you. What don't you have that you should have? And that can be a real problem. California does not have a standard of de minimis time anymore. So we owe every moment that someone, in the opinion of the building behind me, suffers work. Now, I like working, and I know a lot of people that like working. So I don't know that we would view it as suffering work, but that's the legal phrase. And we owe someone every minute of that time. And so you're right, going ahead and having them review all of that material on site, maybe through our iPad or our computer where they can sign off on that, having the time to review that pays dividends way far down the road. That if you hire right and you get someone that's going to be in your environment long enough, that 3 hours that you paid at the beginning, it looks inconsequential in the end. There are real big benefits from technology, and we want everybody to be able to be reachable through their cell phone about shifts that they may want to pick up or questions about where things were in the walk-in because we can't find something. If you're going to set it up that way, okay. Otherwise, the manager text chain, the WhatsApp group chat should go away. And then we need to have documentation reinforcing the idea that you can access all of this stuff through the POS. And if you're doing it any other way, it's for your convenience. I would say there's one big advantage that restaurant owners have is their personalities. They're getting into a hospitality business for a reason. So we need to use that advantage. The advantage comes up and gets used typically in fostering a relationship during a life of someone's employment with the restaurant. It's like a bank that you're making ongoing deposits to. Now, you're going to make withdrawals at some point from that bank. The size of your withdrawal is going to depend on what capital you invested in that relationship. And the size of the withdrawal is going to be based on how much did you bank early on in the relationship, and then how did you conduct the final separation of employment or the level of discipline. I always advise people that a termination should never come as a surprise to an employee. And the only way that's going to happen is if you've talked to them ahead of time so that it's just not a surprise. You've given someone every chance and it simply can't work this way anymore. But the personality of a person starting a restaurant is something that can do that very, very well, because they will bank so much that at the end, if done correctly, the person's going to know why they're being separated. You may get someone that goes out with their friends over the weekend and grouses a little bit, but you may not get the person that starts searching the TikTok videos, filling out the intake forms, and then causing you to get the demand letter. That's a strength of what restaurants can do. Having a design system like that serves you so well. If you're looking to be able to replicate a restaurant concept in multiple locations, you need to create a system that each manager can consistently follow each and every time. So not having a system there, that can be a real problem because the managers won't have that system to follow. It reminds me of my father's saying when I was young. It was the 6 P's. Proper prior planning prevents poor performance. So by going ahead and devoting some of that exciting energy when you're creating a concept and starting a restaurant, but devoting some of that energy to this less exciting aspect of it, that planning, that's going to go ahead and prevent that poor performance in the end. All right, take care, everybody.